Good afternoon, everybody. Welcome to the Saturday edition of the People Show's Legal Hour with Mark Wallace and my guest, Judge Lenard Murray, who's going to be joining us in just a few minutes. We're going to be answering all of your legal questions that you have. Remember, the judge can't give you any legal advice, but he can certainly answer all of your legal questions. All you have to do is to tap or chat or type in your question in the chat, and the judge will be able to answer your questions. However, this is a pre-recorded show, so the judge is not going to be able to answer your question, but we're going to be talking about some things. We're going to be talking about evictions. We're going to continue our conversations on the administrative review. There's some other items that we're going to be talking about today that will be important information for you to get if you certainly know somebody who may be dealing with one of those issues, or you may be dealing with one of those issues yourselves. So we're going to talk about that as soon as Judge Murray comes into on the show. Also coming up on the Monday night edition of the People Show, we're going to be talking about Newt Gingrich, what Newt Gingrich said in comparing Donald Trump to the civil rights workers and those people who died and bled and were tortured back in the 1960s. There are some things that just cannot go unresponded to. And Newt Gingrich, the disgraced former Speaker of the House himself, who is somehow trying to suggest that Donald Trump, who is facing 88 felony charges, that somehow that somebody's out to get Donald Trump as though he is that special. He is not. He is not above the law. He has had a privileged life, and he needs to be held accountable for the things that he's done. But certainly, Newt Gingrich needs to be held accountable for what he has done and what he has said, and the insult of Black people who have been tortured and other people who have been tortured in the civil rights movement. Donald Trump has never been tortured. We're going to deal with that on the Monday night edition of the People Show. Make sure that you tune in to that on Monday night. Now, I have constantly been reminding us how important it is for us to organize. We've got to organize ourselves together so that we can make sure that we are in a position of power to make the kinds of demands that we need to make to those people who are in charge of our government. And if they're not able to meet those demands, then we have to be in the positions of power that we can draw our own slate of candidates to replace the people who are not delivering to us. It is really that simple. We have to use power. So that means we have to take power, we have to organize power in order for us to be able to enforce the kinds of things that we need to enforce. Now, not about trying to hate on anybody or just trying to be vengeful. What we're trying to do is to be liberating. We want to liberate our people. And nobody is going to liberate our people but us. It has got to come, and it's only going to come through mass struggle. That means that you and I have to commit ourselves to this struggle. So we're building this block. We have to build a block. It is the only way that we are going to amass power to influence public policy, to transcend and transform the conditions of our community. We're going to talk about that on the Monday night edition of the People Show. Make sure you tune in. It's going to be a good program. All right, joining me now, as he normally does every week on the People Show's Legal Hour, Judge Lenard Murray is the supervising judge at the Cook County Circuit Court and the we call it a housing division, but it's more real estate, as well as he is the supervising judge over the administrative review. Judge Murray, how you doing?
Good evening, Mark. I'm sorry. Good afternoon, Mark. How you doing? I'm doing well.
Doing great, doing great. All right, thank you for joining us. So last week we were talking about the administrative review, and that got quite a few views. There were quite a few people who were happy to hear about that, and we said that we wanted to elaborate on that and continue talking about that process. So can you give us some sort of like uh, um, a review of what we talked about last week, and then we can move right into this week's discussion.
Sure. Well, I think um, one of the most important things to be mindful about in administrative review is the fact that it is a review process. It is not a trial tribunal. So you don't get to bring in new evidence or offer new testimony on review. You can make the argument that what occurred was not consistent with what the facts were in the law, but you don't have the ability to then offer something new um, other than make the argument that what you did submit should be sufficient to change the outcome. Um, and quite often, well, I won't say quite often, but often, uh, people go to hearings, request hearings, or submit their protests by either mail or email. And let me, at this point, remind your listeners and viewers that uh, you can contest a city ticket usually in three manners. First, you can submit a protest by mail. Uh, you send that to the city. There's a PO box to which those protests can be submitted, or you can do it by email. So essentially, what you would put in an envelope and deposit in, with the postal service and have it sent to the city, you can essentially fashion that same argument and make and put it in the form of an email attaching whatever documents that you believe are helpful to your position and submit that electronically. Or you have the ability to show up in person at one of the city's various hearing sites and request a hearing on whatever the issue is that you've been cited for. Now, there's some city citations that require your presence. You can't contest it by mail or email. For example, uh, if you've got a citation for your glass being too tall or something to do with the condition of your property, those typically have to be protested by in-person hearings. You don't have the ability to protest those by mail or email. Um, and there's some others. Normally, the citation that is issued to you will suggest to you the methods by which you can contest the issue raised by that citation. But those two examples that I gave you, protesting a citation, administrative citation regarding condition of your property, um, or something as simple as um, your grass is too tall. Those must be done in person. You can't do those by either mail or email. But getting back to the point of how you fashion your protest, essentially, if you select mail or email, that is your hearing. You don't get to go back and redo that. You don't get a do-over in that context. Now, if you show up in person to protest a citation, uh, you need to reveal whether or not, when your matter is called, whether or not you are prepared for hearing that day. Because typically, in my experience, if once the hearing starts, and somewhere along the way you realize that I am not ready for this. I should have. I need to gather up information or documents or photographs or whatever it is, or even bring in a witness. Of course, you can't do that unless you first suggest that you need time to prepare. Because once that hearing starts, the city begins to put on their case. Um, or if it is a matter that is done based on documentation, where typically the city does not produce a witness, they're likely not going to allow you to start over on another day. So it's very important that you are aware and know what your ability is on that day, especially particularly the first day. Because if you show up and suggest I'm ready for hearing, they're going to take you at your word.
Right. Well, I've always been reluctant um, to contesting tickets by mail because I just think that, that is an easy opportunity for the administrative reviewers or whoever it is that's looking at that to just, decide in favor of the municipality. I've always thought that it makes you have you have a better chance. Not that you have the vision, but I've thought that in person um, it weighs it has weight in terms of you being able to defend yourself or to certainly to make your argument.
I think you're right based on what I've seen. I see a number of situations where folks have attempted to protest a ticket by email or mail. You're not present, so you don't get a chance to even raise a second point
Mhm.
by virtue of your being there and maybe remembering something that you might not have included in an email or mail protest. That ability is gone. Because you got to remember that when you submit a protest by mail or email, that is your hearing. It's
Mhm.
as if you were before a hearing officer and defending your case. And again, what we do is review what's occurred. We don't take testimony. We don't accept evidence. At that point, you can't, because what we're doing is reviewing what's already occurred, reviewing the record. And the record will not contain any new submissions by you. So therefore, they're typically not allowed. Now, there are some limited situations or circumstances where you might be able to submit something that was mentioned in a transcript of an in-person hearing.
Mhm.
Remember, in-person is where you show up and you register your defense uh, to whatever the situation is, whatever the citation is. Uh, and you do that as best you can in terms of what you think you need in order to overcome the alleged violation. Um, and again, we review what you've done. So there are situations though where uh, I've seen transcripts where a photo has been offered and the hearing officer, for whatever reason, fails to include uh, that photo or their document or whatever it is as part of the record. And then in that circumstance, if we see where that document was in fact referred to uh, in the transcript, then we can look at that. We can determine whether or not that item, whatever it is, photograph, document, some other type of record, uh, should have been considered and may have affected the outcome. So in that circumstance, we can, but you have to make sure that you make mention of that document during the proceedings so that we can review the transcript and see where it was mentioned and intent was made to utilize it as part of your response to the city's case. Now, uh, one of the things I do is I read every record. We do have a law clerk in our division who assists us, but I have just by habit, I suppose, or practice, believe that it's important for me as well to read the transcript. The law clerk uh, does not necessarily have to be a licensed lawyer to be a law clerk in the circuit court. There are some who are. In fact, the law clerk is in our division. Um, he's been out of law school for quite a while. I'd say he's probably been out of law school for 6, 7 years, but he only recently passed the bar. Now I don't know what that necessarily says, but in any event, he's not a licensed lawyer yet, um, and we don't always get licensed lawyers to work as part of our staff. It's not great pay, great experience, but not great pay.
Hmm.
I've always felt that it was important for me to see exactly what the record is, and then uh, utilize the benefit of his memo to see if there are issues that I picked out as part of my review, and see how they dovetail with what's in his memo.
Okay. All right. So, okay. So there's a few things that you said that I think is critical. In the administrative review, it is a review. It is not like you're having a regular tribunal. It is a review of what has already been argued or decided at the administrative hearing, um, which is the first phase. Now, what I have run into is that I talk to people, they would call me and say that they had a red light camera ticket and they wanted to contest it. And I would say to them, okay, let's see what your defense is. Because there are some things that people bring up that's not a defense at all, right? So, and then when they go to court and they use the argument that they use, which again works against them, right? As opposed to them making sure that whatever the basis of their argument is, that they have that succinct, because should they lose, which they probably will lose at the administrative hearing, then they have the opportunity to address that same thing that that administrative hearing officer found them liable for. They now can come before you or one of your judges to argue that very point and to see if they can prevail.
Right, because well, as you say, it's those red light camera tickets, they're cameras. They are supposed to capture the event, and the reason that they were activated is because the sensors that are embedded in the is triggered by movement, and at least the theory is that that movement suggests a violation of a city code of some sort. The red light could be speeding, um, uh, other sorts of violations, that pertain to motor vehicle operation. So one of the situations I see fairly often is where folks come up and they say, "Well, I got a ticket for turning on red," uh, and I said, "Well, let's see what the video says." And normally, what happens, what often is this case, is that they didn't come to a stop. So even though you can turn on red, you must first stop. So
Right.
their turning on red event is that they turn on red without obeying the red light that says stop. Then you can go. So
Hmm.
once pointed out to them, normally they see what the fault is in their action. Uh, and then there are other situations where sometimes the camera gets triggered uh, when a turn on red is allowed uh, uh, during hours that are later. And many of the no turn on red corners um, are from 7 a.m. to 7 p.m., but they're different hours around the city. So I have seen situations where folks have been ticketed because they turned right on red after having stopped, but for some reason the camera system was triggered by that movement, and a ticket was generated even though it should not have been in that circumstance. So it's
Gotcha.
important to look at the video to see whether or not you were compliant and came to a stop. And I know there's a lot of definitions of what a stop is, but essentially it's one where the movement of your vehicle is such that I learned this from a police officer many years ago, where the movement of your vehicle has come to a halt, such that a person could cross in front of you without being hit by your car.
Mm-hmm.
And I thought that was a pretty good test, because if you in fact have stopped, someone would be able to cross in front of you without colliding with your vehicle. So I use that from time to time to explain why I believe, even though you were permitted to turn right on red, in this instance, you didn't sufficiently stop because if someone was crossing in front of you, you would have run into them.
Right, right. Um, it is amazing to me that still this way that when people come and ask us for some guidance or some direction, the first question I ask them is, have you seen the video? And by and large, they have not even looked at the video.
Yeah.
So I'm glad that you raised that, because it is very important for people to go and look at the video, because you can save yourself a lot of time.
Yes. And it's possible, even if you filed a case and then realized that there was in fact a violation. It's possible sometimes to ask the judge if we can reduce it, if you can settle it by restoring it to the original fine, so that the whatever the additional late payment amount is, you can avoid, as long as you agree to pay the original fine within a certain period of time. And in those instances, typically, I believe the judges in my division at least will do that. They'll accept the admission to resolve the case.
Gotcha. Okay. Let's turn to evictions. I had an interesting call this week where someone said that her landlord, she's moved out. She did not pay the last month rent, but she moved out, and the landlord says to her that if she doesn't pay, that he's just going to go and put a judgment on their name, and he doesn't need to go to court.
Well, that can't happen. He may be able to file something with the credit bureau to suggest that this person didn't make a rental payment and show it as a unpaid debt against her, credit history and score. But he cannot obtain, if it's a he, that's the way it was here, cannot obtain a judgment against the former tenant without filing a lawsuit.
Mm-hmm.
And that entails creating a complaint, getting service on this tenant through the sheriff or a private process server, if that's granted, and having a court date where the former tenant would be able to show up and contest it, but the burden would be on the landlord to suggest that in fact there is a month's rent due. This is the amount, and I have not been paid. So, but he cannot, without initiating a court action, have a judgment placed against the former tenant. It's not possible.
Mm-hmm. Okay. So I hope that answered their question, that they do have to have their day in court, so to speak.
Right, yes.
Mm-hmm. Okay. What about, I spoke to you about this. What about someone whose landlord is not responding, and they got a pretty severe issue with rodents, um, and the landlord just has not even taken any significant steps, and they're just saying, well, you know what, I'm not gonna pay rent, and I'm gonna find another place to live because I can't live like this.
Okay, well, I think they could reach out to the city building department, and they will send out inspectors to observe the condition present in that unit. And if need be, contact the landlord and maybe initiate a case if the landlord continues to be unresponsive. But under the Chicago Residential Landlord Tenant Ordinance, well, let me back up a minute. And I don't know if I've mentioned this or not, but it's really important as to why all of the towns, cities, and villages in Illinois have the ability to regulate health and safety as it pertains to their political subdivisions. And Chicago
Mhm.
is such a location. Um, so there is because of the home rule provision under our state constitution, uh, these towns, villages, and cities have the ability to regulate matters that pertain to health and safety within their political territory. Uh, as such, uh, such things as condition of property, uh, operation of motor vehicles, certain other types of criminal activity not otherwise regulated by state law is left to the infinite wisdom of local elected officials, such as aldermen. Um,
Mhm.
and and outside Chicago, the number of suburban towns, they have the same ability as Chicago does to enact ordinances that deal with health and safety within their territories. And also, there are sections of Cook County which are unincorporated. So
Mhm.
in those areas, Cook County government is in fact the local government for those areas which are not otherwise a part of a town, city, or village. And in fact, they have building codes and so forth that govern those territories. Um,
Mhm.
so a number of years ago, uh, Chicago City Council enacted what's referred to as a residential landlord tenant ordinance. Um, this document this law ordinance was intended to regulate the relationship between tenants and landlords within the city of Chicago. It is a fairly broad document. I won't take the time tonight to try to go through the whole thing, but one of the provisions allows a tenant to withhold rent in order to
Mhm.
cure certain defects that exist in their dwelling unit. However, you first must give notice, and if my memory is correct on this, I believe it requires that you give the landlord a 14-day notice suggesting that if you do not cure this defect, and you have to specify what the defect is, then I will use uh, my rent payment uh, to cure that defect. Now, you can't merely withhold rent. That's not a defense. So if you give this notice suggesting that you're going to withhold rent to cover the cost of the repair, uh, then you must do so. Because if you don't, then that is not a defense, and you're in a situation where you're in a rent default, and the landlord could serve a notice and then thereafter file a case in the circuit court and
Mhm.
ask for possession of the unit that you're in. So if you withhold the rent, you must use it in order to pay for whatever the repair is. And it's not just limited to situations of trying to uh, eliminate pests,
Mhm.
such as insects and rats and mice and so forth. There are other kinds of repairs that you can also undertake pursuant to that ordinance. But again, it requires a notice to landlord, and then a sense of what the cost of the repair is. In the more detail that you provide, the better. So in that circumstance that you described, that tenant, after no, if it's a Chicago tenant, after notice, would be able to withhold rent in order to effectuate the repair that they have given the landlord notice of, so that they can eliminate that hazard within their unit.
Mhm. Okay. All right. That's good stuff. That's good stuff. Um, I wanted to shift a little bit to some, I guess I want to call it national politics, but I think we can sort of weave the process in there. So you have Newt Gingrich, right, who is so desperately trying to influence the election that he comes out and he turned uh, the former president into some sort of martyr, saying that he is, uh, when he sees him, it reminds him of the civil rights movement. Um,
When he
and
sees Trump,
pardon?
when he sees former President Trump.
Yes, yes.
Okay.
So this is Newt Gingrich who goes on and takes this position that somehow that there is this fantastic conspiracy between the Justice Department, um, uh, the Stormy Daniels, and all these other people, but somehow that this particular defendant is only being treated this way because he, hadn't done anything wrong. But what he did is he compared what's happening to him that he said that was akin to what happened to civil rights workers in the 1960s.
Hmm.
Um,
That's a curious analogy there.
well, yeah, we're going to deal with that on Monday because I think that that's something that just cannot go unanswered to. It just cannot go unanswered to. When you think of all of the people who died and bled and suffered in the civil rights movement, Donald Trump hasn't suffered anything but his ego. And somehow to suggest that he is being treated similar to just seems to be nothing short of an insult for those people who lost their lives and who were tortured during that period of time for simply wanting to go and vote.
Yeah.
I found that to be pretty astonishing. Pretty astonishing. All right, so
I'll look forward to hearing that conversation.
yes, yes, okay. So you wanted to talk about something related to housing, I think it was, right?
Yeah. Wanted to, I guess, get folks who decide to buy condominium units, particularly those where they reside in, to really have a full sense of what it means when they do that. Um, and I
Okay.
think the first thing they've got to realize and be aware of is the fact that they have agreed now, by virtue of the purchase of that condominium unit, to be part of communal living. That they are going to live in a residence with a number of others, and essentially agree to accept whoever it is might also be an owner and resident of that dwelling, that development, as a neighbor. Um,
Mhm.
in addition to that, these condominium developments have a board of directors who are comprised of other owners. And you have the ability as an owner to vote for who those people are, and in fact, run for election yourself to
Mhm.
be part of the management. And I think it's important for folks to realize that upon buying a condominium unit, you can't sit on your hands. You've got to remain active because uh, if you don't uh, select the right people to be part of your management, if you don't keep your eye on the ball, so to speak, in terms of what's happening, and complain and protest where necessary about what you see in your environment, uh, then you may not be very happy with your living situation, and it may be costly to you. Uh, One of the cases on my docket now is what's called Ford City Condominium Development, and it is just east of Ford City Mall, that shopping complex,
Mhm.
along Cicero around 76th Street, 75th Street, in that area. Um,
Mhm.
and it's 320 living units there, um, which I was not aware of. I had no. First of all, didn't even know anything about the fact that there was a condominium development there, and secondly, uh, the fact that there are more than 300 units there is really just amazing to me. And they comprise either six or seven um, structures that house and hold these units. Um, and it would appear that they've had uh, a number of years of mismanagement there, such to the point that they are millions of dollars in debt. I think um, the number is probably somewhere around 20 million. Um, and they're facing the prospect of having to deconvert their condominium development. Now, just to explain what that means, is that when a condominium uh, conversion takes place. There's a whole set of documents that must be done, surveys, uh, bylaws, the declaration itself, et cetera, um, to convert from what might have been a single or multiple units into a development that combines all of these living units into one development. Um, so when that occurs, then that also puts in place a management system, uh, usually comprised of unit owners whose job it is to manage the development, meaning hire the right people, property manager if need be, scavenger, security, repair entities, contractors, whatever it takes to maintain the property. Well,
Mhm.
they've got a number of years of mismanagement and also a question of why the bills have not been paid. And their water system is connected to Ford City Mall, and it's suspected that the water bill's been unpaid for a number of years in terms of what uh, their usage is to the Ford City Shopping Center. They don't have a separate meter, if you will, to tick off usage. So there's some agreement apparently that was entered into a number of years ago that suggested, I guess, took a guess at what the usage is, and that's the number that has been paid. Um, so that bill has not been paid for a number of years. And then, there's always the allegations of theft and mismanagement and so forth. So they're facing the prospect, and many of these people, they're minorities, Black and Hispanic, uh, and they're facing the prospect of having their units forcibly sold from them as part of the deconversion. So it's really a tragedy. Uh, and unfortunately, there may not be a way out here in order to save this development. And then, we got the prospect of where do these people go? If it's sold to someone uh, who then decides that they want to go in a different direction relative to who occupies those spaces, then those folks are facing the prospect of having to find new housing. And Chicago already has a housing shortage. Um,
Exactly.
we are many thousands of low-income living units shy in the city. The last number I heard was 20,000. It's probably at least 50% more than that now.
Hmm.
So how do we compound that situation by these folks, not all of whom are necessarily low-income renters, but it's still a problem with trying to uh, find housing for themselves and their families. And, many of these people have been owners in this development for 20 years or more. So, where do they go? So it's a tough question. It's a very difficult situation. Uh, and, we're trying to approach it to make the best decision for everybody concerned. The case all came about based on a number of building code violations that exist there. So that's how the situation came about. And it's my understanding that the current case is not the first case that was filed against the development by the city.
Hmm.
This is probably at least the second case. So it would appear as if the first time around, um, the approach may not have been aggressive enough in order to stem the tide at that point and right the ship. So uh, we're now trying to deal with this. Um, and the nice people that I've encountered, but it's a tough slog in terms of what the outcome ought to be here.
So these are people who, for all intents and purposes, put a chunk of money down, invested in this property, paid a mortgage uh, on this property, only to be at threat to losing it and maybe never getting any equity from it. That sounds like the potential of what you just explained.
That is the potential. We don't know the particular situation of all the owners because, as I said, there's more than 300 of them. I don't know what their individual mortgages are. I don't know what their balances are. All those are things that will have to be worked out as we go forward. Um,
Hmm.
but it's not going to be a simple process. And you're right; these people who have put their life savings in some situations into having a safe and stable place to live. Many seniors. Um, so it's just unfortunate. I made the statement early on that, when you buy a condominium unit, you cannot just sit idly by and sit on your hands.
Right.
You've got to be active. And it would appear to me that some of these folks just were not active. And some of what's involved here may well just be outright theft. I don't know that their financial operations were ever audited. So we really don't know what happened to uh, the assessments that were levied and hopefully collected on this unit, these various units. Um, and then you've got situations
Mm.
where there are folks who are behind on their assessments because they sense that the ship's going to sink. So therefore, why should they pay assessments when others aren't? So it's
Wow.
complex, um, and it's going to be a tough decision that's going to have to be made. And
And
there are two methods.
this is a case.
Yeah, it's the case that I have. And there are two methods of deconversion. One is a voluntary deconversion where the owners can vote to deconvert. And if my memory's right on this, the target percentage requirement is that 85% of the owners must vote yes to deconvert. Or you can have an
Mhm,
involuntary conversion where by petition of the city,
mhm,
they can ask the court to order the deconversion of this development because of health and safety issues. Really not so much economics, but the economics come from the fact that there are repairs that can't be paid for. But it's not purely driven by economics. It's kind of the result of mismanagement and where the dollars just are not there in order to cover the cost of the repairs around the
mhm.
development.
Well, yeah, it sounds like it's going to be a tough decision to have to make, but it almost seems like it's inevitable that that's the route that they're going to have to go. And um, from my perspective, it sounds like there's no because even if they stay, they're going to be putting a special assessment on them, which is going to make usually it's going to work against them. It's not going to favor them.
Yeah, and I don't know that most of them can afford to pay a special assessment. You know,
Right.
the cost that it's going to take, first of all, there's two levels here, layers. What first is their debts, unpaid debts, and then there are the uh, repairs that are necessary to bring the property compliant with city code. So
Mhm.
you got two things going on here, and I don't know if anyone has done the math in terms of how many dollars are necessary in order to, one, pay off the debt, and secondly, uh, uh, undertake the repairs to bring it compliant with code.
Mhm. Well, yeah, that's a very difficult position to be in, where like you say, they probably are not super expensive units, but to them, they have to save up their life savings to be able to get that one unit, only to find out now that they may end up having to give it up.
Right. Yeah.
Yeah, yeah. Well, I wouldn't want to be in a position to have to tell them that. So, is the building currently vacant or not?
No, it's not. It's multiple buildings that were converted as a single condominium development. So I believe it's six buildings that comprise this 320 units.
Wow.
So some of the buildings are multi-level buildings. So you may have several floors, 6 or 7 floors with multiple living units on each one. And that's how we get to the, more than 300 units involved in this development.
Wow. Well, we certainly wish them well, and hopefully uh, some small miracle will come into place, because it will be just a shame for people to have put down a chunk of their savings, um, only to find out that you bought some temporary time.
Yeah, and I discovered recently that one of the owners here has has been purchased her unit within the past couple years, and I was curious about that because I said, "There's no way that if you had a traditional closing, that the fact of the bankruptcy and the city case could not have been revealed on your title commitment.
Yeah.
So I don't know who's, what the nature of the transaction was that led her to become an owner. But I said,
Mm.
there's no way that the court case plus the bankruptcy filing that the association undertook could not have been known to the title company that guaranteed the that you in fact own it, possibly only subject to the mortgage that you may have taken out in order to finance your purchase, if that's what you did.
Wow. Wow. Yeah. Um, but and then what you have also is if they have mortgages, you have the institutions that are also going to end up being losers.
They could, because if it's an involuntary conversion, meaning the court orders it, then the homeowners aren't stuck with any shortage
Mhm.
that could exist in terms of the payoff of their loan. That by state law, they walk away debt free. They don't leave with a check, but they won't have anybody chasing them down to pay off whatever the difference is.
Mhm.
Versus the voluntary conversion, where they would be liable if there is any shortage relative to their own particular unit. And that's
Wow.
why I was saying, this is not it's not a simple situation here. It's really
No.
complex.
Yeah. Yeah. Well, hopefully, hopefully these people, have some alternative to do it. And they don't even have, because of the condition of the building, they don't even have the right to sell their unit.
There have been some transfer or change of ownership. I'm not sure how that took place. It may well be
Mhm.
that folks were bailing out, so they just gave quitclaim deeds and the buyers just took it subject to whatever was present. Um, but yeah, you're right. There is that possibility
Mhm.
with those in those situations.
Right. Right. Yeah. What a shame. What a
Yeah.
shame. Kind of reminds me of what happened out in, I believe it was Hazel Crest Country Club Hills, where they had to pay this special assessment for the $80 million that Walmart got to open up a store
Oh,
in one of the,
in the mall.
yeah,
Yeah.
the homeowners got stuck with the bill,
Yeah.
and some of them were already paying 20,000 a year. Now they're paying, I'm sorry, yeah, 20,000 a year. Now they're paying uh, that plus another $20,000 special assessment.
Wow.
So that story reminds me of, what do these people do? They've worked hard all their lives just to certainly be in a position to own a home, and now it's being taken away from them.
Yep.
Yeah. So, all right. Well, listen. Hopefully, you can keep us in sort of informed about how that works out. So, is it because the association didn't pay the bills, didn't do the preventative maintenance that you need to have on a building of such size?
Yeah. It's all of that. And then, there's the allegation that past board or board members, stole money. You've got that element, possible element in the mix as well. And then
Mm,
not enforcing the need for current owners and occupants to pay assessments. So it's really a compound situation where
right, So it's like there's some comparative negligence on the board as well as uh, the the members.
Yeah.
Yeah, yeah, yeah. So, oh well, that shines a little bit of a different light on it. It's still a tough situation, but it shines a little bit of light on it because it would be one thing if the people were just helpless, but if they're also participating in their own decline, you know, it's like who comes to the table with clean hands?
Yeah, and they're putting it on past boards. The current group seems to be pretty conscientious, and they got a spotlight on them, so they're not walking away with dollar bills in their pockets. That's not the current situation.
Mhm.
Because they're under the eye of the bankruptcy court, and then you've also got state court involved in terms of sort of the day-to-day management, um, and the need to comply in terms of health and safety issues. So
Mhm.
it would be difficult, I believe, in this current environment for someone to be nefarious with the assets of this development.
All right, all right. All right, folks, look, that's going to do it for us this week, Judge Murray. Again, we reminded people that this is a pre-recorded show, but lots of good information out. Make sure you tune in. It's going to be on at 1 o'clock on Saturdays, as we usually are, but it's pre-recorded, so you won't be able to type in your answers or your questions to be answered, but you're going to get a lot of good information, and we will return next week with back to our usual format where we're live and you will be able to participate in the questionnaire. Judge Murray, thanks so much. We certainly appreciate it.
All right, thank you, Mark.
All right, we'll talk to you soon.
All right.
All right, look, that's going to do it for us for this week's edition of the People Show's Legal Hour with Circuit Court Cook County Judge Lenard Murray, who provided some good information on some housing. We still went through the review process and dealt with that. So we certainly look forward to you all tuning in. So make sure you tune into that show on Saturday, and I'll be right back with you next week. We'll be live. Monday night's edition of the People Show, we're going to be dealing with the Newt Gingrich, comparing Donald Trump's being on trial to what happened to the civil rights workers in the civil rights movement. All of that's going to be coming up on the Monday night edition of the People Show. Stay tuned.